Ladies and gentlemen, welcome to another episode of PLA with myself and Nick and Bruno. Your favorite host is back after one episode of being away, and we're gonna jump straight into it. We've got two questions. One is a Facebook question from an anonymous, and his question is that, or his or her, there's a sale of a property, right? The property has been sold. She co-owns the property with somebody else, 50%. And the other owner, the purchase price has been paid, and the other owner has now disappeared, or he's not giving over her 50% share of the sale of the property or the money. So what are his options there, Nick, in terms of what can the person do basically to get over, to get their 50% share paid over back to themselves?
Perfect. Okay, so for me, there's two aspects to this particular question, because there's a question of the actual transfer of the property. So in terms of this question, they say they did co-own the property, and the property seems to have already been transferred. They have now received the remuneration for the sale of the property, and it seems like that's already been paid to one co-owner. Okay, but there are two aspects to this. The first is the actual transfer of the property. So now, remember, if you are purchasing a property in South Africa, you have to do this on a written document. It's a requirement in South Africa. It's got to be in writing. It's got to go through the registry, okay, in order for a proper effective transfer to go ahead. And in terms of that agreement, okay, the way the payment is going to happen in respect to this particular property is going to be set out in that particular agreement, okay? So you often find that with property transfers, there's a deposit and a bond has to be secured within a time period. Okay, this is all set out in the document. But what's important for the purposes of this question is there's also going to be a provision on how that remuneration for the property is paid. Generally, 99% of the time, this is going to be paid upon registration transfer, i.e. in the deeds registry says that property now sits in the purchaser's name. The payment goes from the conveyancer's trust account and gets paid over to the sellers in the circumstances. What we don't know here is, was that deed of sale complied with? I'm assuming that it is, okay? And I'm assuming that in the circumstances, the payment was properly made into one of the purchaser's accounts that was indicated in the sale documents, okay? And there's no problem there. Because if, say, that isn't the case, and there was perhaps a payment into account, one of the owner's accounts, and instead it was supposed to be 50-50, our writer's got a couple of options specifically with relation to the conveyancing attorneys in the circumstances, because they would have breached their duty on the sale agreement. But we can't see that here. I just mention it because it's a possibility if the circumstances do dictate that happen. In this case, though, it seems that what's happened is there's been a proper transfer, payments has gone, and it's been given into the account that was indicated on the sale documents. That would be one of the sellers. So they didn't take the steps and say, we're going to split this purchase price and pay each of you a bit by bit. And it's all gone to the one purchaser. In the circumstances, it seems like there isn't a problem with the actual transaction. So you can't do anything with conveyancing attorneys. And now it's a dispute between, obviously, the two co-owners of this property, okay? And the unfortunate circumstance in this case is that there's going to have to be some level of litigation if that owner is not going to come to the table. So obviously, what you do in the circumstances is firstly say, listen, where is my 50% share? I would assume in the circumstances that's already happened. If they are not coming to the table, if they're ignoring you or whatever the case is, unfortunately, this is one of those circumstances where you're now going to have to demand the payment of that half share. And essentially what I think it would form is a case of an unjustified enrichment in the circumstances, because the person who has now holding the full purchase price has unjustifiably been enriched by the sale of the other 50% owner's share of that particular property. And in the circumstances, you'd have to approach a court to say, look, I need the return of that purchase price, or at least a damages portion in what I've suffered, which would be my 50% share in the circumstances. So unfortunately, no easy answer. Maybe this, maybe our writer gets a bit lucky, approach an attorney, try with a letter of demand, and see if you can resolve it on that particular circumstance. But you know, if this owner is unfortunately trying to run away with the full purchase price where he's only entitled 50%, it's a case of you're going to have to institute an action for the return of that 50% which you are owed.
Yeah, I think that certainly that covers it in terms of remedy. Thank you. So Anonymous, there you have it, and we hope that you do follow that advice, and then feel free to reach out with us, and we can also obviously from BSA or SLR we can also assist you in this type of matter litigation.